Hi everyone, this is Arkady Frehktman. I'm a New York City personal injury trial attorney, and today we're doing a deep dive into some recent New York verdicts and settlements. So let's get into it. Here's the first case, and this is recent in 2024. It happened May 7th, the trial did. And this was a case in the Bronx. On April 14th of 2019, the plaintiff, her name was Carolyn, she was 49 and unemployed, and she was in the bathroom of her apartment on Valentine Avenue in the Bronx, and a portion of the ceiling fell on her, and it caused her to fall into the bathtub. And she claimed injuries to her neck and back, and she sued the property's landlord and management company, and she argued that they were negligent in their maintenance and repair of this property. And according to her attorney, she had complained about the leaky bathroom ceiling for at least 20 years, and it was never fixed, or not fixed properly. Now, the defense argued that the defendants acted reasonably in their maintenance of the ceiling, and they further claimed that a plumber had visited the plaintiff's apartment approximately 9 days before the incident. And per the defense attorney, the plumber had concluded that everything was safe. And the defense claimed that the ceiling collapse stemmed from a leak in the apartment above the plaintiff. So it was like an unforeseeable leak, and that's what caused the collapse. Now, the injury was that the plaintiff had a C4, C5, a C5, C6, an L3, L4, an L4, L5, and an L5, S1 herniated disc. And in January of 2020, she had a 2-level cervical fusion that included disc resection, decompression, a partial corpectomy, and microforaminotomy. So she had a pretty invasive surgery, a 2-level surgery. But then she also had a 2-level lumbar fusion in June of 2020, about 5 months later. And that surgery involved disc resections, a decompression, and a partial corpectomy. And then she had a second lumbar surgery in December of 2020 that included a laminectomy, a fastectomy, a foraminotomy, and neurolysis. So the plaintiff's counsel said that the plaintiff is experiencing ongoing pain, and she was diagnosed with a failed back syndrome. And she claimed that she will need doctor's appointments, imaging studies, physical therapy, medications, injections, ablations, a home health aide, and 2 additional surgeries in the future. So she claimed damages including $450,000 in past medical expenses and $5.5 million in future medical expenses. So just the future medical expenses were $5.5 million. And the defense's damages expert gave the opinion that the plaintiff had spinal degeneration and that the plaintiff's surgeries were not related to this accident. I recognize the attorneys that represented the plaintiff. I know them, they're good trial attorneys. And I recognize the attorneys for the defendant as well. I've had cases with them. They're also pretty good attorneys. The defendant had a biomechanical expert, a radiologist expert, and also an orthopedic surgery expert. And it lists who the insurance companies are. But the settlement was for $7 million. So a pretty good settlement. I mean, there were a lot of surgeries, but you know, in the Bronx, especially if you have $5.5 million in future medical just expenses that you're gonna require, I guess $7 million is a pretty good settlement. And always the good thing about a settlement is that you're guaranteed that money, as opposed to getting a verdict, right? You can get a verdict of like 17 or 70 million, but it's just a verdict on a piece of paper, then they're just gonna appeal, and the appeal is gonna take 3 to 5 years, and then who knows, they might say, you know what, you got a verdict of 17 million, but just do the trial again because of this technicality, whereas a settlement is like a guaranteed money in your pocket, so it's always good. Okay, let's go to the next case. This one is out in Nassau County, and this was a crash. What happened here was that on June 7th, 2020, the plaintiff, who was 50 years old and an electrician, was a passenger in a car being driven by his uncle. And the vehicle was traveling on Route 208 in Ulster County. And so the driver, the uncle, lost control of the car and hit a tree. And so the plaintiff claimed back and hip injuries. And so he sued the uncle, and he claimed that the uncle was negligent in the operation of the car by hitting a tree. And he specifically argued that the crash occurred while the uncle was demonstrating a burnout. And according to the plaintiff, the vehicle sped across the center line, left the roadway, and struck a tree. So I guess he was demonstrating some kind of maneuver, a burnout, and that's when he hit the tree. So Anyway, so the plaintiff moved for summary judgment on liability, and the motion was granted. As it should be, because he's a passenger, he didn't do anything wrong, so he should get summary judgment. So the issue was all about damages. And here, the plaintiff was diagnosed with an L1 wedge compression fracture, so a lumbar L1 compression fracture. And he also claimed avascular necrosis of the left femoral head. And he received cortisone hip injections, a spinal cord stimulator. He ultimately had a total hip arthroplasty, which is a total hip replacement, in September of 2022. And the defense said that the avascular necrosis was due to his excessive alcohol consumption. And the parties negotiated a pretrial settlement, and the settlement was a total of $650,000. So what happened here was that the insurer tendered a $250,000 primary policy and then paid an additional $400,000 from a $2 million excess policy. So the total was $650,000. So not a bad number, but I would think we had a total hip replacement case and we settled it for 1.2. So sounds a little light, but they're in Nassau County, which is kind of a conservative venue, so maybe they didn't want to risk it. I don't really recognize the plaintiff's attorneys. I don't know them, but it looks like a firm out in Suffolk County. And the defense firm, I do recognize. They're like a typical, one of the defense firms for a big auto insurance company that you see all the time. Here's a case, actually, maybe this one is worth doing. It's an interesting case. What happened here was on October 1st of 2018, that's the date of the incident, a plaintiff, a 29-year-old guidance counselor, was driving her car near the intersection of the Van Wyck Expressway and Hillside Avenue in Queens, and her vehicle was involved in a crash with an 18-wheeler. So she argued that the driver of the 18-wheeler struck the rear of her car after she merged into the left lane of the expressway. However, the 18-wheeler driver claimed that the plaintiff initiated contact with his truck, and he argued that she misjudged the amount of space available and subsequently hit the side of the truck when she was merging. And so the trial was bifurcated. Damages were not before the court. It was only liability. And the damages were tears of the shoulder supraspinatus tendon. Yeah, there was also herniations in the neck as well as the lower back. There was physical therapy, acupuncture. There was an arthroscopic shoulder surgery. The treating surgeon said that the plaintiff would have trouble lifting heavy objects and performing daily activities. And a radiology expert for the plaintiff said that she would require future follow-ups, diagnostic testing, physical therapy, chiropractic treatment, epidural steroid injections, assistive devices, and home health care. And the defense's radiology expert gave the opinion that the plaintiff's shoulder injuries were chronic and pre-existing, that they were already there before. The demand was $450,000. The offer was $7,500. The trial took 2 days and the jury deliberated for 1 hour. And the verdict here was, it was a defense verdict. The jury decided that the truck driver was not negligent. So I guess they had strong proof that when she merged over, maybe she did hit the side of the truck, which you have to be careful with, when you're driving, because you do have trucks. Now, trucks could be negligent, trucks could hit you, and then trucks do have, obviously they're huge. Sometimes they weigh 100,000 pounds. You can get very seriously injured. But if someone is changing lanes and there's not enough space and they actually hit the truck, the truck can't stop on a dime. It's a huge tractor trailer. So I guess they had strong proof that the truck was not at fault. And this was decided in April 30th of 2024 in Queens, and the jury gave a defense verdict, and the incident was October 1st of 2018. So you could also see how long it takes, about 6 years to get to court. So that's kind of not so good. It takes 6 years to get to court just to get nothing. So that happens. So I don't want to make the false impression that every case is, millions and millions of dollars. Sometimes cases go for nothing. Here's another defense verdict case with a water leak in a subway station, and it was a serious injury. It was a comminuted right distal tibia fracture with open reduction internal fixation surgery, which is very serious. It was a photographer's assistant, 44-year-old, was walking down a staircase on 42nd Street and 7th Avenue subway when he slipped and fell and sustained these leg fractures. And so they sued the New York City Transit Authority. This case actually happened February 14th of 2014. So really old. It takes a long time with the transit authority. And the trial was in April 23rd of 2024. And so he argued that there was a defective bulkhead above the staircase, and the plaintiff's counsel moved for summary judgment, which was granted, but then the first department, the appellate division, overturned the ruling and said you have to do a trial. And the defense argued there's no evidence of any leak coming from the bulkhead. And they further argued that the fall was not caused by any alleged leak nor by any negligence from the New York City Transit Authority. And the defendants had an engineer expert as well as an orthopedic surgeon. The plaintiff had an orthopedic surgery expert as well as an engineer as well. So they both had the same experts. And so the jury, I won't go through all the injuries, but the jury determined that the defendant was negligent in that the subject's stairs were defective. However, they concluded that the defendant's negligence was not a substantial factor in causing these injuries. So for whatever reason, it doesn't tell you exactly in the write-up, they gave you the negligence, that the defendants were negligent, but that there's no causation, that this negligence didn't cause the fall. And there was actually an offer on the case. There was an offer of $300,000, and the demand, it doesn't say what the demand was, there's none reported. The trial took 13 days. The jury deliberated for 3 days, so they must have thought about this case a long time. And the jury vote was 6-0, and the jury was 4 men, 2 women, 1 black, 1 Hispanic, and 4 white. And the trial happened in New York County, which is Manhattan. Here's a verdict, kind of an interesting case. A pedestrian claimed that the back and knee injuries after being hit by a truck. So this was in Queens. So what happened here, the trial was April 15th of 2024. It was for a plaintiff who was a lady, 33-year-old. It stemmed from an incident that happened on December 23rd of 2013. So a long, long time ago, more than a decade ago. The plaintiff was 33 years old, a housekeeper. She was struck by a pickup truck. The incident occurred on Hudson Street near Spring Street in Manhattan. The truck's driver was doing a left turn onto Hudson from Spring, and she claimed back, head, and knee injuries. Now, she sued the driver, arguing he was negligent, and argued that there was a traffic signal that permitted her entrance to the roadway and that the defendant failed to yield the right of way. Plaintiff moved for summary judgment on liability, and that motion was granted. So this was a damages-only trial. And so what happened was she had tears of the meniscus in the right knee. She also alleged a traumatic brain injury with post-concussion syndrome, headaches, cognitive deficits, and was diagnosed with an L4, L5 herniation. She had arthroscopic right knee surgery in February of 2014 with a partial medial and lateral meniscectomy, a partial synovectomy, and chondroplasty. And she had several rounds of physical therapy and received epidural steroid injections. She then had a lumbar microdiscectomy in 2023. So yeah, there was a life care plan, there was a lot of medical expenses, there were a lot of gaps in treatment, because this was going back to 2013. And the jury determined that she sustained a significant limitation of use of a body function or system. Because remember, you have to show a serious injury. So they did determine that, and they concluded that she sustained economic damages that exceeded the basic economic loss. So the jury awarded her $799,889, but she was not awarded any medical expenses for treatment related to her alleged traumatic brain injury. So I guess the jury didn't believe the traumatic brain injury, but they believed the other injuries. And so the way it broke down was it was only $5,000 for past pain and suffering, $23,000 for past medical expenses, $1,900 for past medical expenses for treatment at a specific hospital, $10,000 for future pain and suffering for 37.8 years. So if you look at the non-economic damages like past pain and suffering, future pain and suffering, it's only $15,000. The big money that was given was $672,000 for future medical expenses for 37.8 years. So that's how it all added up to $799. It was a 4-week trial. The jury was out for 2 days, and the jury vote was 6-0. And the jury was comprised of 6 men. There's another interesting case here. We can go through it. Maybe quickly, I'll just skim over it. This will be the last case. This is a case out of Manhattan. What happened here was it was tried on April 12th of 2024. And it was in New York County in Manhattan. and it involved an incident that happened on June 21st of 2017. And the plaintiff was a 36-year-old tax attorney, was walking on the sidewalk near 173rd Street, and what happened was an L-shaped piece of aluminum window capping fell from the third story of the building, and the 5-foot by 2-foot window capping struck him in the head. So he sued the property owner, the corp, he sued the manager, I think it's called Woods Management Group, and he also sued the company that had supplied and installed the window, Adler Windows. And he claimed the defendants were liable for a dangerous condition that caused the incident. So before trial, the court granted the plaintiff's motion for summary judgment on the issue of negligence. The court held that the defendants were negligent in allowing the capping to fall and in failing to erect a sidewalk shed as required by the building code. And so the jury was asked to decide whether the capping actually struck the plaintiff in the head. So that was the issue, right? Because whether it actually hit him. And according to plaintiff's attorney, an independent eyewitness claimed the window capping did strike him in the head. And plaintiff's counsel also noted that the window had an incident report stating that the capping had hit him. So an employee of the company for the building testified that the plaintiff was not struck in the head, and then the window company employee stated that he heard the plaintiff say that the capping did not hit him. And so the injury was a cervical sprain and a traumatic brain injury. And also the incident exacerbated his bipolar disorder. And so he received Botox injections, magnesium infusions, acupuncture, physical and vestibular therapy. He took migraine medications and saw a therapist for his bipolar disorder. And he had to see optometrists and neurologists. And his counsel maintained that the objective medical evidence supported the plaintiff's traumatic brain injury, and the plaintiff's attorney argued that his injury could have only been caused by the falling window capping. So yeah, he had this brain injury, migraines, cognitive deficits, impairments with his processing speed, attention, and focus, and he claimed that the accident led to behavioral issues, vestibular imbalance, nystagmus, and saccades, and that the injuries make reading and computer work difficult. He initially returned to work with accommodations from his employer, and he was eventually discharged and has been unable to find new employment. And plaintiff's attorney argued that he's totally disabled. He had a life care planner give the opinion that the plaintiff needs additional doctor's appointments, psychological counseling, medications, acupuncture, and physical and vestibular therapy. And so he sought recovery of $100,000 in past medical expenses and $2.2 million in future medical expenses, as well as $8 million in past and future lost earnings. And he sought recovery of damages for his pain and suffering, and the attorney asked the jury to award $40 million. And the defense argued that the window capping could not have caused the plaintiff's injuries since the capping did not actually strike him. And so the jury actually returned a defense verdict. They concluded that the plaintiff was not struck by this window capping. So I guess for whatever reason they said, and there was actually a demand of $8 million with a $3 million high-low, and an offer of $5 million with a $1 million high-low. The trial took 4 weeks. The jury deliberated for half a day. The jury vote was 5-1, and the plaintiff's attorney filed a motion to set aside the verdict as being against the weight of the evidence, I guess. But interesting, it just goes to show, like, even you never know how a case is going to play out. Like, you would think that would, and I'm looking at the experts. The defendants had experts in biomechanical, psychiatry, vocational rehab, ophthalmology, brain injury, as well as neuroradiology, and the plaintiffs had experts in neurology, vocational rehab, optometry, life care planning, radiology, economics, and neurology, as well as clinical psychology and physical rehabilitation. They had a doctor who kind of is a brain injury specialist. I recognize his name, but he's a physical medicine doctor. So they had excellent doctors, but I guess it really turned on this question of whether or not he was actually hit, and they had some kind of evidence, or for some reason they believed he wasn't hit. Okay, I hope this was helpful. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families and making sure that you get as much as possible in your injury case. If you need any kind of assistance, feel free to text me, 347-566-9595. I'm happy to chat, and all the best, and we look forward to seeing you on the next video. Okay, have a great day.